After you create a trust, your next step is to transfer your assets into your trust. But what if you own a business interest? Should you transfer that into your trust as well? I'm Daniel Hunt, a certified specialist in estate planning, trust, and probate law. Transferring business interests into a trust can be complicated, but in this video, I'll share an overview of the basics. First, why should you transfer your business interests into a trust? Here are two reasons to do so. Reason number one, avoiding probate. Just like any other asset, business interests that exceed the California probate threshold can trigger a lengthy, expensive, and public probate proceeding. Assets that are placed in a trust do not need to be probated. Reason number two, incapacity planning. A trust ensures that your business can continue operating not only upon your death, but also if you become incapacitated due to an accident or illness. If your business interests are placed in a trust and you become incapacitated, your successor trustee can immediately take over your duties to keep your business operating during your absence. Before transferring your business interests into a trust, you should always consult an experienced estate planning attorney. Depending on what kind of business interest you own, they can help ensure that this transfer won't violate the corporation's bylaws, an LLC operating agreement, or any shareholders buy or sell agreements. Your attorney can also draft a trust that specifically grants the trustee powers to manage your business. Each type of business interest has its own requirements, so working with an attorney is key to avoid any potential missteps. Next, let's talk about how to transfer business interests into a trust. This process will vary depending on what kind of business interest you own and how it was set up. Here are a few of the most common types of business interests. In a sole proprietorship, you are the only business owner. Because a sole proprietorship is not considered a separate entity, you would transfer the sole proprietorship into the trust. Even though a sole proprietorship is not considered a separate entity, you'd still want to transfer that sole proprietorship into the trust. You would simply assign your business assets into the trust with an assignment signed by you listing out all of the business assets you are placing in trust. If you own stock or shares in a corporation, you should contact the corporation and fill out any necessary documents to transfer your stock or shares to a trust. Often this document is called an assignment of stock. Submit the document to the corporation and have them file it. Next, the corporation will reissue you new stock or shares listing the trust as the owner. Check with your corporation on any additional terms or conditions when making trust transfers. When it comes to a limited liability company or a general or limited partnership, you may own a complete or only a partial interest in the business. You'll want to first review the terms and conditions of your LLC or partnership agreement to review the requirements for transferring your portion into a trust. If there are other partners, they may need to vote on and approve the change. Next, seek counsel from your attorney on the best way to transfer your portion of the business into your trust. This will vary depending on how your business was set up. For an LLC, you may need to execute an assignment of interest, notify your partners, and sign a document agreeing to the change. For partnership, you may need to change your partnership ownership certificate to your trust as the owner of that share. When transferring business interests into a trust, an experienced estate planning attorney can provide legal advice on how to best achieve your goals. If you have any questions about transferring business interests into a trust, please feel free to contact our firm. Thanks.